We have a very important development in one of the most critical challenges to state bans on rifles and magazines. Recently, the Trump administration made a significant move by stepping in and officially arguing that these state bans are unconstitutional. This marks a major step because it adds weight to the ongoing legal battle, and now the case is set to move forward to oral arguments. The case at the center of this fight comes out of Illinois. It challenges the Protection of Illinois Communities Act, which restricts the ownership of so-called assault weapons, as well as limits the capacity of firearm magazines. A federal district court judge, Judge Stephen McGlynn, previously ruled that the law violates the Second Amendment and struck down the ban. But the state of Illinois immediately appealed that ruling to the Seventh Circuit Court of Appeals, asking the higher court to overturn Judge McGlynn's decision and reinstate the restrictions. In its recent filing, the Trump administration argued that Judge McGlynn's ruling was correct and should be upheld. The administration's brief emphasized that banning commonly owned rifles and standard magazines violates the Second Amendment and cannot stand under the Constitution. In their view, the analysis used by the lower court judge was faithful to Supreme Court precedent, while the reasoning applied by the Seventh Circuit in earlier decisions was flawed. Illinois, on the other hand, continues to defend its ban. The state argues that the Protection of Illinois Communities Act does not actually infringe on the Second Amendment, and that earlier rulings by the Seventh Circuit upholding similar restrictions should control the outcome. Illinois insists that Judge McGlynn disregarded the higher court's instructions in a previous case known as Bevis, and therefore his ruling should be reversed. This clash is now moving to a decisive stage. The Seventh Circuit has scheduled oral arguments for mid-September, which means both sides will present their full positions before the court. With the Trump administration now entering the fight, the challenge has taken on even greater national significance. Now that the case has reached the stage of final judgment, there are three major reasons why the Seventh Circuit should reconsider its earlier stance and instead uphold the district court's injunction. First, several key elements of the Bevis decision were flawed, even when judged by the standards of Supreme Court precedent at the time. In other words, the reasoning in Bevis simply does not hold up when compared to the constitutional framework the court had already laid out for Second Amendment protections. Second, since the Bevis ruling, multiple justices of the Supreme Court, most notably Justice Clarence Thomas, have openly signaled their disagreement with the logic used in Bevis and similar lower court opinions. These justices have made it clear that the court is likely to take up a case in the near future to directly correct those errors and provide stronger clarity on the Second Amendment. Third, after the Bevis decision, the district court conducted a thorough bench trial over several days. During that trial, significant amounts of evidence were presented and carefully reviewed. The court ultimately made factual findings showing that the Illinois law does, in fact, violate the Second Amendment when applied to commonly owned rifles and standard capacity magazines used for lawful purposes. Taken together, these reasons form a strong basis for the Seventh Circuit to reverse its earlier course and affirm the lower court's injunction. This is why the Trump Department of Justice filed an amicus brief in strong support of the plaintiffs. Their position goes beyond just rifles. They argue that other related items, such as detachable magazines, firearm suppressors, and a wide range of attachments and accessories, are also protected under the Second Amendment. The brief laid out a firm stance that these items are not exotic or rare, but are in common lawful use, and therefore fall within the scope of constitutional protection. On the other side, however, the state of Illinois has now filed its response, directly challenging these arguments. Illinois contends that the Trump DOJ's position should essentially be disregarded. They argue that the firearms and accessories in question are militaristic in nature, designed for battlefield use, and therefore not protected by the Second Amendment. According to Illinois, the evidence developed on remand supports the conclusion that the Protect Illinois Communities Act is constitutional. They insist that the plaintiffs' claims rest on nothing more than the belief that Bevis was wrongly decided, and that the district court's ruling should not be given deference on appeal. Illinois stresses that this court reviews questions of law independently, and that the district court did not provide any binding factual findings that would limit the Seventh Circuit's ability to rule differently. The state goes further by asserting there is no valid reason to disturb or modify the Bevis decision. They claim Bevis properly applied Supreme Court precedent. is consistent with rulings from every other federal appellate court to address similar bans, and is fully supported by the record and the evidence presented. In short, Illinois is urging the Seventh Circuit to reverse the district court's ruling and reaffirm what it had already stated in Beavis, that the ban is constitutional and should stand. The situation is now reaching a critical point, with oral arguments officially scheduled for Monday, September 22nd. This is going to be a pivotal moment. All eyes will be on how the state of Illinois and the Seventh Circuit judges handle the arguments raised in the amicus brief filed by the Trump administration's Department of Justice. One major question is whether the court will take those arguments seriously or simply sidestep them. In fact, Illinois largely ignored the Trump DOJ's brief in its most recent response, almost as if the strategy is to pretend it doesn't exist and hope the judges won't bring it up during arguments. That alone raises eyebrows and makes the upcoming hearing even more important to watch. Now, it's worth remembering that the Seventh Circuit does not have a strong record when it comes to the Second Amendment. Historically, they've leaned heavily against it, much like the Ninth Circuit, where pro-Second Amendment cases often face setbacks because of the court's political and ideological leanings. That said, this Illinois case has the potential to push beyond the Seventh Circuit. Why? Because even though the Supreme Court has recently denied review of several rifle ban challenges, including those already at the final merits stage, Justice Kavanaugh has made it clear in his statements that the court cannot continue to avoid these issues forever. He specifically noted that the time is coming, possibly in the next term or the one after, that the court will take up a rifle ban or magazine ban case and finally provide a definitive ruling. That means if the Seventh Circuit once again rules against the Second Amendment and dismisses or downplays the Trump DOJ's position, this Illinois case could very well be one that the Supreme Court decides to take up. It's precisely the kind of case that fits what Kavanaugh was signaling in his written remarks when the court declined to hear similar cases in the past. And this isn't just about Illinois. The outcome here is massive for other states with similar bans. For example, the Duncan case out of California, which challenges the state's magazine ban, is also currently seeking Supreme Court review. If the Supreme Court is serious about addressing these issues in the near future, these two cases, the Illinois Piquet challenge and the Duncan case, are prime candidates to be taken up. So as things stand right now, we're looking at a crucial oral argument in September that could set the stage for a showdown at the nation's highest court. Whether the Seventh Circuit continues its anti-Second Amendment pattern, or whether this becomes one of the cases the Supreme Court finally uses to establish new precedent, remains to be seen. But one thing is certain. The stakes are incredibly high, not just for Illinois, but for the entire country. That's the current update on the Illinois Piquet challenge and its implications for both rifle bans and magazine bans nationwide. As more developments come in, I'll keep you fully updated. If you found this breakdown helpful and want to stay informed on these critical cases, make sure to hit the subscribe button and turn on notifications so you don't miss the latest updates. And as always, thank you all for your continued support.